Later on during the interview, I had taken a brief break and I came back, and then he had said, I bullshitted you. I did just purchase another firearm, and it's in my desk. When I had asked him about the threats that were written in the letter, he said, no, not in that letter.
A man and his wife walked 2 hours to reach a courtroom in rural Wisconsin, not knowing they were walking into a legal scandal that had been hiding in plain sight for over a month. His name was Brandon Campo. He had no lawyer, no transportation, and as it turned out, no actual charges filed against him. Yet for 33 days, he had been living under $1,000 cash bond, terrified of violating conditions tied to a case that, on paper, did not exist. How does a man get jailed, bonded, and bound by court conditions for a crime no prosecutor has formally charged him with? The answer exposes a quiet but explosive failure inside the American justice system. And it took one judge to drag it into the light. Campo was arrested on May 22nd. 4 days later, on May 26th, a court set his cash bond at $1,000 based on a police probable cause statement. The document officers submit describing the facts that justify an arrest.
It will be admitted at this time without objection.
Thank you, Your Honor. Detective, who was the letter addressed to?
It was addressed to Chief Judge Kyle Seedorf.
Was there any identifying information in this letter that you received that led you to a potential suspect in your investigation?
Yes, so the letter was signed, thanks, Matt, as well as it contained an email address, mbritton, I think 54@gmail.com.
Probable cause is a relatively low legal bar. It means there's enough evidence to believe a crime probably occurred. It is not the same as a formal criminal charge, which is what actually triggers prosecution, court dates, and a defendant's right to know exactly what they're accused of. Campo had cleared the lower bar. He was still waiting weeks later for the higher one.
What information had been gathered by your agency at the time that you're assigned to this case?
Initially, there was information regarding a letter that was delivered to a courthouse. One of the sergeants from the courthouse had been shown the letter and had done kind of a preliminary report on it, identifying a suspect.
Okay, so tell me more about this letter and how it came to be delivered to a courthouse.
Yeah, so the letter was actually initially dropped off at the Broomfield County Courthouse. One of the clerks there came in contact with the letter and then immediately notified the Adams County clerk in regards to the letter. And then from there, the letter came to the Adams County Courthouse.
By the time he appeared in court on June 24th, almost a full month had passed, no complaint, no formal charges. Just a man in a shirt and tie walking miles because he couldn't afford a car, just trying to get a court date changed for a case. Nobody could tell him the status of.
gmail.com. And then the contents of the letter referred to a specific HOA case, an ongoing HOA case that was being handled by Judge Chanel.
You've talked with us about surveillance video from the Broomfield Courthouse. As part of that, were you able to see the vehicle driven by the male that drops off the letter at the courthouse?
Yes, there is a silver Mercedes sedan that was associated with the male that dropped off the letter.
And what was significant about that during your investigation?
During the investigation, we found that his wife, Casey King, had a registered 2006 silver Mercedes sedan.
This is where the hero of this
sedan.
And when you say his wife, who are you referring to?
Mr. Britton.
As part of your investigation, did you determine where Matthew Britton resides?
Yes.
On May 14th of 2026, as part of your investigation, was Matthew Britton arrested?
Yes.
Okay.
33 days, 1 arrest, 0 charges. And a man still bound by bail conditions for an accusation that legally did
not in that letter.
Detective, can you start by stating your name and spelling your last name for the record?
Yes, Shannon Malowski. Last name is Maloskie.
Where are you currently employed?
at the Adams County Sheriff's Office in the Detective Division
And how long have you been employed at the Adams County Sheriff's Office?
for 7 years.
And are you the lead detective that's assigned to this case involving Matthew Britton?
Yes.
And how did
Schmidt's answer became the moment that would define this entire case. We wait for complete reports, he
Field
said.
Courthouse?
Yes.
Okay. And can you kind of go through what Mr. Britton told you during your interview with him?
So Mr. Britton, I asked him, to talk with me, and he immediately said, oh, it's about the letter. Said, yes, it was. He had explained his situation. He has been in an ongoing civil case with his HOA for several years. This case has cost him thousands of dollars. He's got the potential for assets of his to be seized, losing vehicles. During this case, there was a Judge Janelle, that was proceeding over the case, and he felt like she was not listening to him. She wasn't seeing his evidence. He had tried multiple avenues to bring up the case with the state, with the federal, with the Attorney General's office to get other people to listen to him, and nobody was listening to the evidence that he was trying to present for his side of the civil case. In addition, when I had asked him about the threats that were written in the letter, he said, no, I didn't write threats, not in that letter. And he explained that there were several drafts to the letter. One of the drafts, when he was writing, he was very angry. And that draft may have contained threats, but the draft that he intended to be dropped off at the courthouse should not have contained any threats. He said that he understood the threats in the letter that was dropped off would sound threatening and would be something that he would be concerned about. He explained that while he was writing these drafts, he would have his wife look over them, and I guess when she had looked over them, she had accidentally given him the wrong letter to drop off at the courthouse.
That is
Did
my
he-
office's policy. Then he added something that would prove fatal to his own argument. I don't charge base.
You said that you talked specifically with Mr. Britton about threats from the letter. Did you actually read him the direct quotes from the letter?
I did.
Okay. And so when he told you that he can understand how that might seem threatening, it was in response to you directly reading quotes from the letter?
Yes.
Did he talk with you about including information in the letter about the judge's personal residence?
Yes, he had said that he looked up her address and then found an image on Google Maps, and that was the image he used in the letter.
The judge caught it instantly. Then we cannot avail, the judge said. If the office wasn't ready to charge, it had no legal basis to keep a man bound by conditions in the meantime.
Did you ask Mr. Britton about any firearm that he owned or had recently purchased?
Yes. Initially, he told me that he did have a handgun. It was from his time in the service, and it was somewhere in the basement. He couldn't recall where. Later on during the interview, I had taken a brief break, and I came back, and then he had said, I bullshitted you. I did just purchase another firearm, and it's in my desk.
And did he tell you what type of gun that he had recently purchased that was in his desk?
He did, I believe. I can't remember specifically what it was. It was a variation of handgun, a black handgun.
Have you ever
Did
worked
you-
for a boss who set a deadline for you but exempted himself from ever meeting his own deadlines? That is, in essence, what was happening to Brandon Campo. The rules that
Did you interview Casey King on that same day, May 14th, 2026?
Yes, I did.
And who is Casey King?
Casey King is Matthew Britton's wife. She knew that Matthew was writing letters, that he was angry. They were both very angry. She had recently noticed that he purchased a firearm, which is something that they hadn't had in their household prior to the recent events. She had noticed that he would stay up for days and nights on end, just writing letters, researching the judge, researching the HOA company, just sleuthing, essentially, is how she called it, how she described it.
Did she speak with you about any additional firearms that he was in the process of purchasing?
Yes, she had said that he had come home one day and mentioned that he had purchased a machine gun. It was at a local pawn shop in Easy Pawn.
Brandon Campo had waited over 700.
A local pawn shop in Easy Pawn.
Okay. After these interviews that you conducted, were you able to follow up with the pawn shop?
I was, yes.
And what did you learn at the pawn shop?
I learned that he had purchased a handgun on May 9th from the pawn shop. And then he also had an assault style rifle on layaway that he began payments on April 30th.
The DA pushed back, insisting his office's internal policy required complete trial-ready reports before filing anything. The judge pushed harder, noting that other counties managed to file complaints the same day as arrest, using the same probable cause statements already sitting in the file.
Are you referring to Matthew Britton?
Yes, I am.
And what did Sergeant Larson observe about Judge Donnell?
She was frightened about the contents of the letter. She had indicated that she read it.
Was Judge Donnell asked if the photograph and address in the letter were actually of her residence?
Yes, she was asked that, and she indicated, yes, those were photographs of her residence.
And did Judge Donnell make any statements as to whether she felt threatened or feared any physical harm?
She did feel threatened, and she didn't want to return to her residence because of that.
The judge even read aloud directly from the police report in front of the courtroom, demonstrating there was more than enough detail to file a charge immediately. Schmidt's office, the judge suggested, was choosing delay as a system, not facing it as a constraint. Here is the moment worth pausing on, the one that will likely end up clipped and shared on its own.
I believe so.
Okay. So the first one was, personally, I would like to blow her brains out. Is that correct?
Yes.
Okay. Those statements were conveyed to Judge Seedorf in the letter,
Yes.
not Judge Donnell.
Yes.
They are not saying that he will ultimately do these things.
Objection, relevance, and it's speculation.
Your Honor,
The objection's overruled. She may answer the question.
It doesn't say that he's specifically going to do these things.
there's another sentence there that said, if you don't reassign her today, you might be my tort lawyer because I might take her out. Is that correct?
That's correct.
And again, it's not saying that he will ultimately do that.
That's correct.
And neither of those.
Schmidt's response was immediate. We will not. The judge
Further
didn't
questions?
All right, thank you. Redirect.
Detective, you were asked a few questions about some of the contents of this letter. And specifically, you were asked about there not being any language about something imminently happening or any of these threats imminently being carried out, right?
That's correct.
Is there information included in this letter that reads, so please reassign her ASAP so I don't go to jail for hurting someone because I'm insanely pissed off and don't like liars and cheaters. It's up to you to do something today.
Yes.
I have no further questions.
Then we will not arrest people. That single exchange captures the entire conflict in 2 sentences.
Detective Malowski has testified that during her interview with Mr. Britton, he admits to writing this letter, People's Exhibit 1. His wife also tells the detective that this letter is written by the defendant And the court has heard testimony that he's seen on surveillance video delivering this letter to the Broomfield courthouse. The mental state for this offense is knowingly. And I think that the language in the letter that the court can review in People's Exhibit 1, as well as the defendant's actions in delivering this letter to the courthouse and then purchasing multiple firearms during this time frame, show that this is knowing conduct that's practically certain to cause the result. The defendant
Brandon Campo was discharged immediately. His cash was ordered returned. The bond, in the judge's own words, was gone.
I won't go any further with that other than just to say, in addition, if that bond is posted, the court also orders that Mr. Brittany obtain immediately mental health counseling. My recollection is it was $50,000 cash only, and then converted to cash for surety. Was it?
I'm sorry, how much did you? I just want to make sure. I think it's I just want to, before I misspeak, I want to look at my screen, but I believe it's $150,000 cash only.
Okay. Let's look at the screen and be sure.
I have $150,000 cash only.
Okay.
For Campo, after 33 days, that was the justice he received. But here's the uncomfortable question.
Are sufficient to believe that a crime occurred and that this defendant is the person who committed that crime. And Mr. Coy, it was your motion to modify the bond, and along with your objection to it being a cash-only bond, the bond schedule amount is $5,000, and this is substantially higher.
Mr. Britton's wife is currently present in the courtroom. He has pretty extensive ties to the area, and he has family who's able to support him. It's an incredibly high bond. We're asking for a reasonable cash surety or property bond. Reviewing the court or the prosecution's motion justifying the bond deviation, we do understand the concerns here. However, I think that there are appropriate circumstances that could be in place, including GPS monitoring, if that's appropriate, and relinquishment of firearms so that Mr. Brandon can be safe in the community. We don't object to any of those conditions. And other than that, unless the court has specific questions, I will stand on my motion.
The prosecution objected, citing Colorado's Victim Rights Act, noting that although stable, Taze existed at the exact moment he was buying guns and writing threats.
And do people want to respond to the request for the modification of bond?
Yes, Your Honor, and largely I rest on the information contained in the motion we filed to justify the bond deviation. For a Victims' Rights Act record, I would like the court to know that I have consulted with Judge Donnell, and she obviously has high safety concerns based on the nature of this case and would object to any reduction in bond for those reasons. In reviewing the defense's request for the bond reduction, it notes, the stable residence, employment history, and ties to the community. What's concerning to the people is that all of these things existed at the time that these...
The judge acknowledged the bond was high, acknowledged the danger, and still left a path for Britton to walk free pending trial. The case is a reminder that the legal system is built to protect even the people who threaten it, and that the line between venting frustration and committing a crime is measured in actions, not just anger. Anyone can feel wronged by a system that seems to favor the powerful. Few cross the line into buying weapons and naming a target. Knowing exactly where that line sits and what evidence the law uses to prove it was crossed is what separates an informed citizen from someone caught off guard by their own government. Tell us in the comments which courtroom case you want broken down next, and if this case opened your eyes to how these charges actually work. Subscribe and share this video so we can keep building a more informed, more accountable society together.